Yes, counsel.
Good morning. May it please the court. Joanne Petito for Bernard Labroad. This case concerns the denial of a motion for Rule 17A2 subpoena filed by the defendant. The denial of that motion violated the defendant's right to a fair trial, including including a meaningful right to present a complete defense and to have access to relevant information bearing on guilt or innocence, or which would be helpful to the defense. The defendant has an unquestioned right to have access to material like that, and that right is protected by Rule 17.
Do we now know what was in that material?
We don't know any more now than we knew at the time.
So that hasn't subsequently been disclosed
No.
and analyzed? Okay.
No, it hasn't. However, at that time, it was known that statements were made by the complainant regarding the alleged incident that led to and formed the basis of the charges against the defendant. And the defendant made his request based on that specific information. It was not a request made based on a broad allegation that the simple fact of mental health treatment.
Did he also ask for, did he also ask for, I just see something in the record about, well, she had ADD, and was there something, he wanted something else besides this particular, the psychologist's records?
The defendant's request was for the psychologist's records. It was also for a request for records from a doctor whose identity had not been disclosed, who had made the referral to the psychologist. I've focused on the request for the psychologist's records.
It was both that he had originally asked for.
Yes, and the fact that it was a referral for ADD is really provided just to give context and also to make clear that this was not a broad request for rape counseling records. This was based on a referral for this potential problem. The complainant happened to make this disclosure during that meeting. And because of that and the obvious relevance to the charges at hand, the defendant requested those records. The standard under Dwyer is not that the material must be exculpatory. The defendant is not required to show specifically what the statements were. If the defendant could show that, the defendant would not need the records, would already have them. This was the problem that this court addressed in Dwyer to avoid setting a standard that was impossible to meet.
But what's the remedy? I mean, let's assume you're right. Let's assume that you should have had that material, and let's assume we say you get it, and then you get it, and it turns out to have nothing that is new. That if you had had it and had sought to offer it, and the judge for whatever reason had said no, we'd look at that and we'd say the error is harmless because this would have had no consequence in the trial. What do we do because we're in this particular situation?
Well, in this situation, I think what we need to do is go back to the defendant's right and the right that was violated. The right was to have access to the information to use in whatever way the defendant saw fit to present a complete defense, to use that information in preparation, maybe to use that information, maybe not to use it at all. It's the defendant's choice as to whether to use that information, and that the significance of depriving the defendant of that choice was actually addressed in this court's opinion in Commonwealth versus Stockhammer, which is an older case. And also the Commonwealth versus Sheehan, in those two cases, that was addressed. It's also been recognized that the information that is sought, and if it's ultimately obtained, may end up not being helpful to the defendant, but being helpful to the Commonwealth. The right that's violated is the right to have the information to use in preparation, and because that the defendant was deprived of that right.
But let's just assume hypothetically that you're correct, that it turns out that, in fact, it's much more helpful to the Commonwealth than the defendant. If the remedy that I think you're seeking is reversal, so a
new trial.
New trial. But the new trial is certainly not going to help you. I mean, it helps your client in the sense that you get another chance at this, but the evidence is not going to help your client, it turns out. Is that the appropriate remedy?
I think it is the appropriate remedy because, largely because the right is really a basic right to use material that may have significance in any number of ways, and it's speculative to decide how the information may be helpful, may not be helpful. It might be helpful for what it contains. It might be helpful for what it does not contain. The point is that the defense and the trial that a defendant is put through should be the result of thorough preparation and a fair chance at a complete defense. And that isn't provided when information like this is withheld.
So your point is that there is no harmless error for this type of violation?
Not for the violation of access to this type of information.
Why shouldn't we, if we agree with you that it should have been allowed, why don't we simply say, okay, you get to look at it, but now you have to come back and make a showing as to how it would have made a difference in the outcome of the case?
You mean, do you mean
Well, that's
before,
a direct
in
appeal,
the
though.
context of a new trial or in
Yeah.
filing a motion for it?
This is your direct appeal, isn't it? I
Yes.
mean, it's further appellate review, but
Right.
you're on direct. yeah.
Yes. Well, I think that under the protocol, the Dwyer protocol, before this information is used in any event, a motion needs to be filed to show that a motion in limine needs to be filed to show that information like this, if it's privileged, could be used at trial. I don't know if that answers your question.
Is the evidence at trial clear that it was this report by the psychologist which triggered the police investigation?
I don't think it was this report that triggered this report by, actually, I don't. I guess it's not clear
Wasn't it the
because I don't.
psychologist who spoke to the DA?
Actually, yes, the report indicates that after this meeting, the psychologist made some phone calls and referred the complainant to the district attorney, so
And
yes,
so didn't it then
Must
get
have
to the
been
police
this-
that way?
yes, it appears so, yes. If there are no further questions, I'll rest on my briefs.
Thank you, counsel.
Kevin Curtin, Assistant District Attorney for Middlesex. It is a direct appeal, and the issue that's raised is the propriety of that pretrial motion. It's reviewed under an abuse of discretion standard. It really hasn't been a showing specifically of prejudice based on this
How
record.
could
It's
there
hard to
be?
imagine how there could be.
How could there be?
How could there be? It's hard to, it's an
Yeah,
interesting
how
question.
could there be? The material hasn't been disclosed. It's been kept from the defendant. How could he show prejudice here?
I suppose you'd have to look at the rest of the record for the trial to see the extent to which the claim that's being made would affect the trial and whether it could possibly make a difference to the jury.
Well,
Here,
you
the
can't
claim
do
was
anything
limited-
unless you see it, right?
I beg your pardon? I'm sorry.
How can, you talk about would it possibly make a difference to the jury, but if we don't know what the "it" is, how could you possibly know?
Well, that's right. It's, I mean, this is the nature of fishing expeditions like this, where you make an assertion of saying that certain statements were made, and I want to get other records, hoping that there's other
But
stuff.
Mr. Curtin, fishing expedition, this is 10 years later, right? She goes to the psychologist reports it to the DA. I mean, I don't know how more specific you could be.
Well, it's the nature of what we're talking about. We're talking about pretrial production under Rule 17 of material that is privileged. And we have a protocol for that is, strictly requires a showing of evidentiary relevance.
But if you don't have the record, how are you possibly going to know, how can you go beyond what was said here?
Well, I mean, they didn't have the record in Lampron, and they made a sufficient showing under Lampron in that case. In that case, there was a sufficient showing, and it was remanded to get the records, and there the showing was the defendant was charged with drugging for the purpose of sexual intercourse. The defendant knew that the victim had consensually taken drugs, according to his affidavit, and he had taken her to the hospital to be treated. And he made a showing that was sufficient to go to the heart of that issue, as to whether it was consensual. And also on the rape, he made additional showings that were in the affidavit, and this court found, based on that type of factual showing, that he should have gotten the records. And so it's not like under our standard, the defendants can't ever get access. They just it's just strictly applied because we're talking about privileged material.
But isn't it really clear that the report that's being sought is what the complaining witness said to the psychologist about the event itself?
What we have is we've got a police report that says that Dr. Gorvin, the doctor, told the officer that the victim had disclosed that the defendant talked her into pulling her pants down and digitally penetrated her.
So this would have been during a session with the psychologist?
Yes.
And it's that was wanted?
Well,
The psychologist presumably had notes?
the notes, but no report, apparently, according to the police report.
Whatever the doctor would keep when,
Yes.
a patient
all it
says
would-
something significant during therapy.
Right, so it's hard to imagine that could be anything different from what the doctor said it was.
Well, how do we know that?
The defendant has to show that. It's not
How
a
is that
fishing.
even
it's-
possible?
Well, you have to, because in a case like this, it really isn't, because the nature of what it is. The police officer was informed that the victim said the defendant talked me into pulling my pants down and digitally raped me. So now the question is,
What did
based
she
on that,
testify,
are you
what
going to
did
get
she
the
testify to
records?
at trial? Just
She
out of interest.
testified consistent with that. So even if that, even if this protocol allows material that is just for impeachment purposes, which is not perfectly clear that it does, but assuming that it does, because that could be exculpatory, something that's substantially impeaching, not impeaching on some minor detail,
Well, that's not-
but very substantially impeaching, then, the protocol could reach that.
The
Here, we
psychologist-
didn't have anything like that.
The psychologist testified at trial?
No.
Was there a first complaint witness?
Yes.
yes, that was the friend.
The friend,
And when did the victim make a statement to the friend?
in ninth or 10th grade, I think it was.
So, but it preceded the
It
statement
was
to the...
preceded the statement by several years. I think it was approximately 6 or 7 years before, in counseling, she made this disclosure.
Now, you say this was a privileged communication because it was made to a psychologist, but am I correct that the psychologist had a statutory obligation to report it under 51B, is it?
Actually, no, because by the time that the psychologist heard it, the victim was 22 years old, and any such report would not have actually been received. So what he did was that he made a referral to the district attorney's office.
But he offered his notes.
He spoke to the police officer. He said he did not have his notes in front of him, but he could create some type of report on request. That's what was in the police
And is it your view that he breached the privilege by doing that?
Well, it's not clear in this record whether that was with the consent of the victim or not, so I can't say that, and I actually do not know.
Mr. Curtin, assume hypothetically that we were to agree with the defendant that actually it was an abuse of discretion on the part of the judge not to allow this discovery. What do you say the remedy is?
Well, this is an interesting issue that we just have been talking about. We're talking about a direct appeal. There hasn't been any opportunity for a judge who could make findings of fact relevant to any claim of prejudice. So I think all you would have to be able, it's hard to say that you should remand it for a hearing, but you're the Supreme Judicial Court. And if you feel that there are circumstances in which there's a possibility of a showing of prejudice on the basis of materials that weren't disclosed improperly, and it ought to go back, but there shouldn't have to be a whole new trial in a case like this, or in any other case that's settled, but there's just this sort of speculative possibility that somewhere in the reports might be something else that hasn't been demonstrated exists. You could, I suppose, create that type of a protocol.
I just don't remember this, but in prior cases, whether Stockhammer or prior ones, was there, or any case, a sort of remand for in other words, the discovery would then take place?
Lampron.
Was
Lampron.
Lampron a conviction or interlocutory?
Should know this.
I'm sorry.
It's okay. I'll tell you. It was an interlocutory petition by the Commonwealth from an order. So yes, that's right. Yep. So the problem with the defendant's position is that he simply could not make, and did not make the showing necessary to get access to these other materials based on the fact that the victim had made this disclosure. So it is entirely speculative that the records might, his notes might somehow have more than this. And moreover,
Do you know if the records are still in existence?
whether those notes that were referenced in the 2005 police report of the doctor still exist, I don't know. You know, but it's, this is a Rule 17 issue. This is not a constitutional issue. This is a Rule 17 for pretrial access to material. And so, I mean, it's hard.
To the fairness of the conviction.
To
mean,
the
it's-
process of the trial, whether it's really due process of the trial. It's not like confrontation or anything like that. We know
Due
that.
process is a constitutional right.
It is. It exists in as part of Article 12, but it's really the integrity of the proceeding that we're talking about. And, you know, the defendant just hasn't made a showing. And there are instances when defendants can make such showings. But we're talking about privileges here, and you pay a price.
Well, let me ask you, what if we don't agree with you, and what if we conclude that he did make a showing? Is there some intermediate remedy that can be fashioned?
Well, I mean, you'd have to make a finding that constituted a prejudicial abuse of discretion, I believe, such that the judgment would have to be vacated and it would have to be sent down for retrial, or you could try to create some type of an alternative or a fact-finding forum in which a determination could be made on the basis of whatever now exists as to whether that would have been any prejudice to the defendant in not having it. But, I mean, we have a system for this. It's a good system. And just because every defendant doesn't get access to privileged documents, there's many states that don't ever allow that. We do.
All right, thank you.